your lordships please appear for the petitioner, and my learned friend Tony Later is with me. He's just a few minutes delayed, but he's shortly here. May it please my lords, Justin Amenuvo appears for the first respondent, with me, A.A. Somoa Asamoah.
Why have you been hiding there, Alexander?
Alexander Somoa Asamoah.
Please, your lordships, Akoto for the second respondent. My lords, with me are my learned colleagues Frank Davis, Kweku Estrefi, and Yao Pong.
Are they your learned colleagues or your learned friends?
As your lordship pleases.
No, let me know. What's the right terminology? Is it learned colleague when you are announcing?
Learned friends, my lord.
This is the ruling of the court. The fundamental issue raised in this objection is whether or not the first and second respondents in this petition could be compelled by this court to give evidence, notwithstanding their express indication to the court that they do not intend to do so. This petition was brought under Article 64, Clause 1 of the 1992 Constitution. The petition seeks to challenge the validity of the election of the president in the 2020 presidential elections conducted on the 7th December 2020. At the close of the petitioner's case, counsel for first respondent announced to the court that the first respondent does not intend to adduce any evidence in the case and therefore wanted its case closed. Counsel for second respondent associated himself with the position taken by the first respondent and reiterated that the second respondent would also close his case because he was not adducing any evidence. Both counsel submitted that having regard to the evidence led by the petitioner through his witnesses, they did not deem it necessary to adduce any evidence in the matter. The two counsel relied on Order 36 Rule 4.3 of the High Court Civil Procedure Rule CR 47 and Order 38 Rule 3E Sub Rule 1 and 5 of CR 47 as amended by the High Court Civil Procedure Amendment Rules 2014 CR 87. Learned counsel for the petitioner has opposed the position taken by the respondent and argued that the respondents, especially the first respondent, cannot refuse to adduce evidence in this petition. The grounds upon which counsel for the petitioner opposed the petitioner's decision not to adduce evidence are that they have both elected to adduce, respondent's decision not to adduce evidence are that they have both elected to adduce evidence in that they have filed and served witness statements as ordered by the court. Counsel for the petitioner argued further that the first respondent in particular, besides filing an answer to the petition, has also specifically deposed to an affidavit in opposition to an application to serve interlocutors in which the chairperson indicated her availability for cross-examination. Finally, it was contended by counsel for the petitioner that the first respondent chairperson performs a very important constitutional function and as such must be made to adduce evidence in his petition to account for his stewardship to the people of Ghana. In their submission before the court, counsel for respondent, particularly for the first respondent, sought to rely on Order 36, Rule 4, Sub 3 of CR 47 and Order 38, Rule 8E of CR 87. We have carefully examined the above rules and our opinion that the provision that is relevant in the determination of this issue is Order 38 Rule 3E of CI 87, which specifically deals with the use of witness statements in civil trials. We deem this rule to be crucial in view of the position taken by counsel for the petitioner, among others, that the filing and service of a witness statement connotes that a party has elected to adduce evidence at the trial. We recall that the filing and service of witness statement in this case was in compliance with an order of this court as part of the pre-trial protocols before trial commenced. It is also an undisputed fact that a defendant in a case can elect whether or not to adduce evidence at the close of plaintiff's case when such a defendant is called upon by the court to open his or her defense. We are of the considered opinion that it would be wrong in law to hold that a party is deemed to have elected to adduce evidence as soon as that party files and serves a witness statement in compliance with the court order. To hold so would mean that once a party files and serves a witness statement, that party mandatorily has to mount the witness box and adduce evidence at the trial. This position is not borne out of the rules. Indeed, Order 38 Rule 3E Sub Rule 5 clearly provides otherwise as follows, quote, if a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence, end of quote. The above rule implies that when a witness statement is filed and served, the party who files it may choose not to give evidence at the trial. The principle is the same in viva voce evidence, where a party or witness who mounts the witness box testifies in chief and fails to turn up for cross-examination. Such a witness cannot be compelled by the court to appear for cross-examination. He suffers the penalty of the evidence being expunged record. This is exactly the position though they are filed and served witness statements. The above rule also points to the fact that a witness statement filed and served does not constitute evidence in law till the author of the statement mounts the witness box, takes the oath, and prays that the witness statement be adopted as evidence in chief pursuant to Order 38 Rule 3E Sub Rule 2, which provides thus, quote, where a witness is called to give oral evidence under Sub Rule 1, the witness statement of that witness shall stand as the evidence in chief of that witness unless the court otherwise orders, end of quote. In view of the clear provisions of the rules referred to above, we do not agree with the submission of counsel for the petitioner that when, as in this case, an answer to the petition was filed at the pleading stage and witness statement filed, the respondents had elected to adduce evidence at the trial. We are also of the opinion that the filing of affidavit in interlocutory applications with the averment that the deponent will be available for cross-examination does not make the deponent compellable to adduce evidence at the trial. Counsel for the petitioner has argued that because the first respondent performs a very important constitutional duty when it is sued in an action such as this case, different rules should be applied. However, counsel failed to refer us to any provision of the 1992 Constitution or any statute which required that the first respondent, being a constitutional body, should be subjected to different rules of the court, and our own industry did not unearth any such authority. The law is that parties before this court must always comply with the no rules of procedure and settled practice regulating the jurisdiction of this court, regardless of the nature of the case. See upon versus Attorney General and others, 1999-2002 Ghana Report 402. The first respondent is not subject to any different rules of procedure because it is a constitutional body. The evidential burden imposed by law on a person seeking to challenge the presidential election results has been settled by this court in the 2013 election petition case. In titled Akufo-Addo and Others versus Mahama and Another, 2013 Supreme Court of Ghana Law Report, Special Edition, page 73. Thank you. After citing with approval several decisions of courts in some Commonwealth countries, notably Nigeria, Uganda, Kenya, and Canada, Ebina JSC concluded at page 218 thus, quote, accordingly, the petitioner bear the burden of proof to establish not only that there were violations, omissions, malpractices, and irregularities in the conduct of the presidential election held on 7th and 8th December 2012, but also that the said violations, omissions, malpractices, and irregularities, if any, affected the result of the election. It is after the petitioners have established the foregoing that the burden shifts to the respondent to establish that the results were not affected. The threshold of proof should, in principle, be above the balance of probability. We have started JSC's dictum to drive home the legal proposition that the petitioner in an election dispute stands or falls on the strength of his or her own case and never on the weakness or otherwise of the evidence of the respondents. Counsel for the petitioner cited to us the case of Smala Biabia versus Ademu Dramani and Attorney General number 4, 2012, one Supreme Court of Ghana Law Report, page 374, in which this court ordered a party to adduce evidence because that party had already adduced evidence in the form of an affidavit. That case is distinct from what is before us now, and it must be read in its context relative to the facts before the court then. In that case, this court was dealing with the submission of no case in a trial admitting affidavit evidence, unlike the current petition, where this court is dealing with witness statements which are unsworn and are not yet evidence. Indeed, the distinction between that case and the current case is clearly demonstrated in the ruling of Dr. Datiban JSC, who delivered the ruling of the court. At page 357 of the report, the learned jurist delivered himself as follows, quote, it is the unanimous view of this court that the first defendant, Ademu Dramani, should be called upon to open his defense in the interest of justice. This case does not have the ordinary characteristics of a trial, say the High Court. The procedure before this court is such that before the commencement of oral testimony, in this case, the first defendant had already put matters in evidence by affidavit. In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first defendant and proceed to an assessment of a no-case submission made on his behalf, as if the evidence on record is that of the plaintiff. End of quote. The distinction here is that in the petition before us, the first respondent has not put before us any evidence in the form of an affidavit or otherwise. As already stated, learned counsel for the petitioner only referred us to an affidavit deposed to by the chairperson of the first respondent in opposition to an interlocutory application to serve interrogatories. That affidavit is not evidence in this petition to enable us compare the first respondent to mount the witness box to be cross-examined. The Smile Abiyabe case is clearly distinguishable on the facts and the law. Now, besides the rules referred to in this ruling, we take notice of the well-settled practice that a plaintiff in a case has a right, that a defendant in a case has a right not to adduce evidence after the close of a plaintiff's case. This right, which originates from the common law, has been incorporated into several trials in our jurisdiction through case law and has been applied in several cases in our courts. The general principle of law is that a party cannot be compelled to adduce evidence in a trial. In this direction, we intend to refer to some cases on this principle of law. In Yamecha versus Ansan, 1989-92 Ghana Law Report, page 152, Court of Appeal, and PRJ, as it then was, delivered at page 155, thus, quote, the plaintiff contended that since the first defendant did not give evidence, judgment should have been entered against him. I do not agree. A party to an action need not give evidence himself. A party to an action needs not give evidence himself. Provided he can adduce evidence of some sort from other sources, the court would have to look at that evidence in considering the totality of the evidence before it. In Baron versus Labi, 1962, one Ghana Report, 168, in the practice note, Olemi Oluwatomi then was delivered himself as follows, quote, a party to a suit is not bound to give evidence, and the court cannot compel him to give evidence if he does not want to. And if a party, having gone into the witness box and sworn or affirmed, elects to give no evidence, his opponent is not obliged to cross-examine him. This procedure, therefore, is not lightened by the absence of the defendant at the trial. The absence of the defendant will aid the plaintiff only when he introduces sufficient evidence to establish a prima facie case of entitlement to his claim. End of quote. In Ama versus Hydroform Estate Limited, 2013-2014, 2 Supreme Court of Ghana law reports 1551 at 1567, which was cited to us by counsel for respondent Benny JSC, held as, quote, a court has no duty to call upon any party to testify in the case. The court acts as an umpire and only hears such evidence as the parties will prefer. Whether the parties will testify or not is none of the court's business. Indeed, a court to insist that the party should testify will amount to the judge descending into the arena of conflict. After determining the tribal issues, the trial court leaves the field clear for the parties themselves to decide who will testify. We know of no law or rule which entitles a court to call upon a party to testify in the action. If such a law or rule does, we would venture to say that it is inapplicable under legal dispensation. End of quote. Finally, we refer to the case of the Society of Lawyers versus Sir William Otto Jeffrey, BT 2000 Queensborough Division Commercial Court, which on the facts is similar in terms of procedure with the current case before us, and cited by counsel for the second respondent. In that case, all the witnesses had served their witness statements in accordance with pre-trial directions under the civil procedure rules, but lawyers had decided not to call them to testify at the trial. An application was made to the court for an order requiring the opposing party to call the witnesses at the trial so that the applicant could cross-examine them. Creswell J. held that in civil proceedings, the trial judge had no power to dictate to a litigant what evidence he or she should tender. There was no obligation to call witnesses. It was counsel's duty to decide what evidence was called and the order in which it was called. The instant court had no jurisdiction to make the order sought. The law is therefore settled that a party will not be compelled to enter the witness box and testify in support of his or her case. It is a risk parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Laws case to the peculiar facts of this petition, because the first respondent, being a constitutional body, with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Laws case, like this petition, also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are amended to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64, Clause 1, challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
As the court pleases.
We are most grateful to the court. And also we are most grateful.
Please, you rise for about 20 minutes.
My Lord, yes. Respectfully, before you rise, I think I ought to notify your Lordship that we will now seek your Lordship's permission to reopen our case in order to have a subpoena on the chairperson of the Electoral Commission. Now, my Lords, we know that we can issue a subpoena without leave, but since we have closed our case on the assumption that she would be, so we intend to file a formal motion We intend to file a formal motion.
Council, it's a court of record, so like you correctly pointed out, you come by your form, you'll be heard.
Very well.
Yes, but you'll come back and give directions for the further trial.
All right, welcome back. So that's us the ruling, and you've heard it coming from the presiding judge, that's the Chief Justice. The witness for the second respondent is not going to mount the witness box. Again, for you to know that the Supreme Court hearing is live on GTV, and Ministerial Vetting is also live on GBC News. Sure. So the Supreme Court hearing is live on GTV. The Ministerial Vetting is also live on GBC News. And the sign language interpretation is provided by Youth Bridge Foundation and the National Council on Persons with Disability. We're also live on radio. We are live on Unique 95.7 in the Greater Accra region, and live across the 16 regions of this country on our various regional and community radio stations, and on Facebook, Ghana Broadcasting Corporation. The judges have just risen for just 20 minutes. We'll see how best we can work with that 20 minutes and take you back to the Supreme Court. We've been joined via Zoom, Dr. Kweku Ajiman Budu, who is a lawyer, he's a law lecturer, and the head of Law Center's Gimpa Faculty of Law. Doc, once again, thanks for joining us and thanks for your patience.
Thank you, George.
All right, help us to understand what just happened, although I've just given the final line that the presiding judge gave out, but help us to understand exactly what happened.
So what happened flows from the discussion we had the last time we met, and basically there were two competing arguments from both sides. The petitioner was arguing strenuously that to the extent that the respondents had filed their witness statements in compliance with the Supreme Court's directions to file witness statements, if any, then they have elected at that point in time to adduce evidence. So there was no question as to whether or not a defendant can decide not to adduce evidence or open their case. It seemed clear that all parties were on an equal footing or understood that particular principle, that it was open to a defendant or a respondent in this case not to adduce evidence at the close of the petitioner's case. The question then now was whether, having filed and served those witness statements in compliance with the Supreme Court's directions, did that mean that the witnesses were going to be called, or that did it mean that they had elected to call witnesses and at all costs they had to call witnesses who would then be subsequently cross-examined? That was the position of the petitioner, that the election took place at that point when they chose to comply with the Supreme Court's directions. The respondent, on the other hand, were of the opinion that on the basis of the rules, or the 38 Rule 3E of the High Court Civil Procedure Amendment Rules of 2014, CI 87, that they could even though they had filed the witness statements, they could decide not to call the particular witness or witnesses to actually testify. And to the extent that the witness statement was not yet in evidence, they could not be compelled to at all costs open their case. And this was the sticking point between the two parties. And we just heard the Supreme Court deliver its ruling on this particular matter, where they essentially uphold, or no, they overruled the objection of the petitioner in terms of the respondents deciding not to open their case or not to adduce any evidence. They cite Order 38. In actual fact, they say that the critical rule that is applicable is Order 38, Rule 3E of the 3E5, I believe, of the High Court Civil Procedure Amendment rules, which provides the opportunity for a defendant or a respondent in this case to file a witness statement but decide not to call that witness to testify or even put the statement in as hearsay evidence, whereas or whereupon an opportunity will then be on any other party or available to any other party to then decide to put in that witness statement as hearsay evidence. So in a nutshell, the Supreme Court has overruled the objection taken by the petitioner in relation to the respondents not opening their case or deciding to close their case and not adduce any further evidence.
Okay, so as we speak, what's the available evidence in front of the court now?
So the evidence that the court has is what has been adduced so far. And the court made mention of the fact that the burden of proof is so that's the evidential burden of persuasion is on the petitioner, and it has been settled in the 2013 election petition. So yes, precisely, where she suggested that the burden was on a petitioner in an election petition of that nature to prove that on the basis of the evidence that they have, there were those irregularities, malpractices, and all that. And once they've done that, they need to, if they've been able to establish that, then the burden will shift to the defendant or the respondent to also adduce evidence to possibly refute that assertion that would have been made by the petitioner. So generally speaking, that burden is on the petitioner in a case, in an election petition case of this nature. So what options are available right now in terms of the air before the court are what has been adduced so far. The testimony of the witnesses that have been called by the petitioner. You remember the petitioner has called 3 witnesses, Mr. Johnson Asiedu Nketia, Dr. Pesa White, and I believe Mr. Rojo Meto-Nunu, Robert Joseph Meto-Nunu. So, and through their testimony, evidence has been adduced. They've tendered in evidence of some sort in terms of some documents that they wanted to put on record, some videos as well, and things of that nature. So the totality of the evidence we have right now is what we have been witness to so far when the petitioner opened their case. So that is the evidence before the court right now.
Okay, just give me about 2 or 3 seconds, or even 5 seconds, for our viewers and also listeners to know that we are live on GTV with this Supreme Court hearing. That's the petition. For the ministerial vetting is live on GBC News. Ministerial vetting is live on GB Parliament, which has got to do with the ministerial vetting, which will take you over. But for now, on GTV is the 2020 presidential petition, which is currently going on, and there's a break for just 20 minutes. Morris.
All right. So we still have Dr. Ajimambudi on the line. Doc, so apart from the 3 witnesses who have come to witness on behalf of the petitioners, the petition itself that was filed by the petitioners, is it also in evidence? Is that evidence?
So the petition contained pleadings, the allegations of fact that the petitioner was making, that this and this happened, and that the chairperson declared in error, or there were errors, and all those kinds of things. So those are the pleadings that they specifically put in their petition. And as we've explained before, those pleadings are, in pleadings, you're not supposed to generally plead law. Of course, you can plead a point of law as to jurisdiction and all that, but generally speaking, you're supposed to plead facts. And after you have pleaded your facts, when you open your case, you will then adduce evidence that will support those facts or substantiate those facts. So that's why there needs to be a connection between your pleadings and the evidence that you adduce. And that's why we've seen in these proceedings that the court has struck out certain pleadings or certain allegations, for instance, not pleadings necessarily. If you look at the witness statements that have been put in and the testimony of the witnesses, we saw that, for instance, with Mr. Johnson Asiedun Ketia, there were certain statements in his witness statements that were objected to, that the court struck out, and on several, or for different reasons, one of them being that they were not pleaded to, or they are not supported or grounded in the pleading. So the testimony that your witness is going to give is supposed to help you substantiate the pleadings that you would have made at the beginning of the case in the petition. So there has to be a connection between the evidence or testimony of the witness that you have called and the pleadings that you have made. So that connection will help you establish or substantiate the facts that you are alleging. And so that is what the petition is. The petition itself contains the facts that you are alleging or the pleadings in your or that you have made, and you need to then call witnesses or adduce evidence through those witnesses to substantiate those facts. So the pleadings on their own is not evidence. It is the testimony of your witnesses and the evidence that is adduced, which is connected to the facts that you have pleaded. That is what helps you substantiate your pleadings or your facts.
All right. So now that the Supreme Court has told us that by filing the witness statement at the case management level by the respondents did not constitute an election to adduce witness, and for that matter, present their witness to be cross-examined. Now, by way of education, at which point would they have been bound, to, as it were, adduce evidence? At which point?
At no point, and for the simple reason that the defendants in civil suits reserve the right whether to call witnesses to testify on their behalf. And it goes to the issue of burden of proof in civil cases, which is on the balance of probabilities, that you, the one alleging that or suing someone or bringing a case against someone seeking specific reliefs, there's a burden that is on you in the first instance, and that's why the 2012-2013 election petition was cited. There's a burden on you to adduce evidence that substantiates the allegations that you are making. And if you are able to do that, then the evidential burden may shift or can shift to the other party or the defendant in that particular suit, then to also call evidence. But even in that case, the defendant can decide that they won't adduce any evidence. They are not. It is not by force that they have to, at all instances, defend the suit. And in this particular instance, what the respondents were saying is that on the basis of the evidence that had been adduced so far, they do not believe that the petitioner has discharged his burden of proof, that he has met his evidential burden to warrant them to even open their case. So what they're saying is that essentially their case should stand or fall on the basis of the evidence that's before the courts right now, and they choose not to adduce any further evidence, which means that the court should be able to decide the matter on the basis of the evidence that they have before them.
All right, Doc, the evidence before the court now is the petitioner's evidence, right?
Generally speaking, yes, because they called evidence first. They made their case first.
So the first and second respondents don't have any evidence at all in court?
not that they don't have any evidence in court, they are choosing not to call evidence. They're choosing, you remember that during cross-examination, for instance, they sought to impugn the credibility of some of the witnesses, yes, and all that. They sought to introduce certain documents, they sought to play videos and things of that sort. But what we can say is that the burden at that point was on the petitioner. So it's not as though to suggest that it is all the evidence in the case is from or emanates solely from the petitioner, but generally it was the petitioner's duty to call evidence in the first instance, after which the defendants or the respondents will decide whether or not they will call evidence on their own behalf or in defense of whatever it is that has happened at that particular point in time. But they believe that on the basis of the evidence so far before the court, the totality of the evidence before the court, that the petitioner has not met his evidential burden to warrant them to even open any defense whatsoever.
And who is to determine whether the petitioner has met its evidence burden or not?
Well, generally speaking, it will be the court that will determine at the end of the matter. But the petitioner, so for instance, there's what in civil trials is referred to as a submission of no case. So a submission of no case is essentially where the plaintiff has closed this case and the defendant will decide that on the basis of the evidence adduced so far, the defendant has no case to answer. So they will make a submission of no case where they are put to an election one.
But there was no case.
Again comes in here. They are put to an election to either stand or fall on their submission, which means that if their submission of no case fails, then the matter ends there, and then except of course if the court decides otherwise. So it is possible, suit will say, on the basis of everything that you've done, I don't think you've discharged your evidential burden, so I won't even bother to open evidence, and I'm making a submission of no case. The court should decide on the basis of the evidence that has been adduced so far that generally has come from your end. It is not unusual for that situation to occur in civil trials of this nature.
Now, for something like this, and to determine the final outcome of a case, is it a risky position or a risky card to take if you are a respondent in cases like this? Because in reading the judgment, you heard the Chief Justice saying that, every responsibility is on the respondent based on the consequences that comes out of this decision taking. What's the risk in such a decision?
It may be risky for a defendant in a civil suit generally to decide not to call evidence. But once again, it's all a question of strategy. It's a question of what you believe, because...
Hello? Doc? All right. Looks like we're having challenge.
Yes.
Can you hear me?
Yes, I can hear you clearly.
All right. So please go on. Your last...
Yes, I'm saying that it... Yes, I was talking about the risk. You were asking about whether there was a risk.
Yes.
Yes. So what I was saying was that it all depends on strategy, and it depends on what you deem appropriate at that particular point in time. So if you're a defendant and you believe sincerely that on the basis of the evidence adduced so far by the plaintiff hasn't even made any case in the first place to warrant you to even open a defense, you take that risk to not call evidence. So what happens is that the court will decide on the basis of the evidence that is before it, which would have at that point been generally adduced by the other side, the plaintiff. And so it's a risk in the sense that if the court finds that the plaintiff's evidence shows that they made their case, essentially the plaintiff has won that particular matter, or the matter will be decided in their favor. So that's the risk involved, because if you choose to call evidence, then you are seeking to sort of disprove or counter whatever evidence has been adduced by the other party. But if you sincerely believe that the other party has not even met their evidential burden, which at the end of the day, like I'm saying, it is the court that will ultimately decide. But you can take that risk and say, I'm not going to call any evidence. The court should decide on the basis of everything that is before it. And so that is what it is. It's possible for you to take such a step.
All right. Doc, we have to go for a quick break. When we return, we'll look at the other options, which was outlined by the counsel for the petitioner, and move into other areas to just, we'll be right back. Just stay with us. We're going for a quick break. We'll be right back.
Shoulder to cry, run on my pumping, so we try was suicide. Yeah, let bygone be bygone. I can't see what I'm gonna do, we go straight to start. I'm gonna take you to the next level. Oh, baby, oh yeah, yeah, yeah. Energy next level. Oh, baby, oh yeah, yeah, yeah. Take you to the next level. Oh, baby, oh yeah, yeah, yeah.
I don't quote this level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
In Ghana, the environmental speed limit of 30 kilometers per hour should be observed in residential, educational, and commercial areas because human activity is dominant. 50 kilometers per hour is for built-up areas and communities along the highway. 90 kilometers per hour is for the highway. The Accra-Tema motorway has a speed limit of 100 kilometers per hour. Where there are no speed limit signs, the national and environmental speed limits apply. So if you're when driving, you must concentrate totally on what is happening in your vehicle and your surroundings. Don't get distracted because distractions cause crashes. Some of these distractions include arguing with a passenger. Also, a long look at a pedestrian will distract you. Other actions that can distract you as you drive include fidgeting with the radio, reaching across to look for something in the car, using a mobile phone or earpiece, trying to fasten a seatbelt, trying to adjust the seating position, and fishing for coins. Please focus on the road as you drive. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
This advertisement has been vetted and approved by the FDA.
Hey, good papa. Ganabam, if your what apostle, your waist, all your body, you make bazaar. Thank you so much. Thank you. What are you doing? I'm about hospital. Ganaba! To wait here from doctor no. Where you there? What massage me? 20 cedi. This is Tiabako. Ganaba, young to to her. I first at Tiabako. I found you be 20 cedis. Hey! We need doctor. Nemo, say we Ganaba will come. Sound two. So if we can Ganaba, you can resist.
Don't forget the balloons,
check.
The DJ,
check.
And the drinks.
Listen, honey, I've got this party under control, okay?
Daddy, don't forget our birthday cake with the sparkly candles. Daddy, are you there?
The parties are 4 p.m., honey. Don't be late.
With the all-new CowPay on the CowBank app and website, you don't have to worry about carrying cash. Just place your order with your favorite merchant and pay with a Visa or MasterCard, mobile money or CowBank account, or scan and pay Visit the Play Store or App Store and download the Cowbank app today. Cowbank app. Forget to cash.
Cowbank. Forward together.
And they call me Eugene. When you need a shoulder to cry, run on my pumping, so we try what you side. Let bygone be bygone. I didn't see what I'm gonna do. We go straight to start. I'll take you to next level. My baby, oh yeah, yeah, yeah. Energy next level. My baby, oh yeah, yeah, yeah. I'll take you to next level. My baby, oh yeah, yeah, yeah.
At Don't Coldness level, excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
The Ghana Trade Fair Company, under the Ministry of Trade and Industry and the One District, One Factory Secretariat, welcomes you to the 25th Ghana International Trade Fair, the premier virtual edition, under the theme, Developing New Trade Opportunities Through Digital Channels. It will be 1 month of exhibition and enterprise, offering manufacturers, suppliers, consumers, and various service providers the opportunity to network and make sales. This February, over 500 local and international exhibitors, factories featuring companies under 1D1F, Rural Enterprises Program, Ghana Export Promotion Authority, and more, all on one virtual platform from the 27th of February to the 28th
of witnesses that would be heard. We close our case on that basis. We are applying to reopen our case, and on that basis, we will be issuing a subpoena addressed to the chairperson of the Electoral Commission of Ghana. And we believe that those processes are necessary processes that would have to be heard and determined in this case. We also intend, subject to receiving a copy of the ruling that you delivered this morning, we also intend to apply for review of that ruling. And that application, we believe, would also have to be heard in order. Very well, my lords, we are drawing your attention to it because we believe your lordship should take that into account in whatever directions you give. We do not think that it would be appropriate for us to have to be bringing applications for stay of proceedings and so on. I think we can do that, but it may be better to avoid going through all those different processes if your lordships would allow us the opportunity to file and have those processes determined.
With all due respect, we cannot prevent a party from filing processes. When a process is filed, the court will come and hear it. Whether it is review, whether it's stay, whether it's an application to reopen the case or whatever, you will come and hear it. But these are the directions. Yes, by court. By the ruling just read, the respective cases of the first and second respondents are deemed closed. This court hereby orders that the parties hearing should simultaneously file their respective closing addresses or submissions on or before Wednesday, the 17th of February 2021. The petition is hereby adjourned to the 18th of February 2021 for counsel in this petition to highlight on the written addresses or submissions so far for the petition to be adjourned for judgment. So we will come here on the 18th of February. Yes. Yeah.
My lords, there is also a matter which arose in connection with your issue 2, and I wonder whether that has been resolved. I think we should, as a matter of record, know. My lords, when we come when?
Based on the data contained in the declaration of the first respondent of, not for, of the second respondent as president-elect, no candidate obtained more than 50%.
Can your lordship go over that again respectfully?
So, whether or not, based on the data contained in the declaration of the first respondent, of the second respondent as president-elect, no candidate obtained. So it's simply that the 4
should be off. That's the only correct.
That is the only correction.
Welcome back, and so we were going back to court on the 18th of February. Between that time to the 17th, they are allowed to prepare their final legal argument, addresses final arguments and all that will address the courts and submit it by the 17th, and then the 18th the court will sit. But before that, you heard counsel for the petitioner raising a couple of issues that they wish to file an application for review of the ruling, an application to reopen the case, and also to subpoena the chairperson of the Electoral Commission. And that's what just happened.
Right, but the Supreme Court has given indication that even though the petitioners have indicated that they would like to open their case, the 2 cases have been closed accordingly.
Yes, for the first and
second.
The 3 actually.
Sure, I mean the cases have been closed accordingly.
Yes.
And so we'll wait till the 18th and see when the petitioners bring their application for a review of this particular ruling, and also an application for an opening of their case, and also to subpoena the Electoral Commissioner to appear in the witness box.
That might even be before 18th, though.
Okay, that will be before.
It might be before 18th, sure, because the court said that for them, I mean, they're there. If you bring in application, they can't stop you, but they can actually hear. Right. Let's move on to talk to Dr. Kweku Agyemang-Budu, and he's joined us back. Doc, are you there?
Yes, John.
Yes.
Yes, I'm here, John.
Okay. Before we went for the break and before we went back to the Supreme Court, I said that we'll be looking at the options given, especially stated by the petitioner or the petitioner's lawyer. First of all, if someone closes his or her case, on what basis can the person reopen the case?
I mean, as the court rightly pointed out, they can't decide for the parties what types of applications they can bring before the court or not. Their role is to adjudicate once applications are before them. So if parties have closed their cases, like I was saying earlier on, you may seek the leave of the courts. And for instance, if we can just give an example, in terms of the witness statements, we know that the witness statement is not evidence until the person who filed that witness statement has been put in the box, or the person who signed that witness statement has been put in the box. But we also know from the Supreme Court's ruling today that the party who files a witness statement can decide not to call that particular witness to testify. And if they decide so to do, either they can also decide not to also put in the witness statement as hearsay evidence. It will be open to the other party. So a plaintiff, for instance, in a civil suit, may then probably, if they've closed their case, may then seek the leave of the courts to reopen their case and try to tender in that witness statement through maybe one of their previous witnesses as hearsay evidence. So that would be an example of a situation that can happen even though the case has closed. But once you rightly know that an application will have to be made and the court will have to grant leave for so doing.
Okay, all right. And like we stated earlier, that hearsay evidence is not admissible.
Generally speaking, hearsay evidence is second-hand evidence, not admissible, but there are exceptions to the hearsay or the rule against hearsay evidence, and this is one of the exceptions where a witness files the witness statement but is not called to testify and does not put it in as hearsay evidence. The other party can put that witness statement in as hearsay evidence because it is not the testimony of that other party's witness, but the other party's witness is putting it in as the testimony or the statement, let me put it that way, that was made by a potential witness. And because it is not first-hand, and because that person who filed that witness statement is not available or is not being called to testify so that he can be cross-examined, that statement can only be put in as hearsay evidence. So that would be one of the exceptions to the rule against hearsay evidence. There are other exceptions, lots of exceptions, actually. Admissions, for instance, confessions, I believe, and other exceptions exist in terms of hearsay evidence.
All right, and the counsel for the petition also talking about subpoena. Exactly help us to understand this process too and what it means.
What, can you take that again?
The counsel for the petitioner talked about an application also to subpoena the chairperson of the Electoral Commission. Help us to understand what this process actually means.
So that's one of the questions that people were even speculating about even before today's ruling. And so it's a discussion of subpoena, what a subpoena is. And even it goes beyond that to even the issue of compellable witnesses. So a subpoena is simply a document or an instrument which is issued by a court to summon an individual or a person to appear in court proceedings, either to testify and or produce a document which is in that person's possession. So if we look at the Courts Act, for instance, Section 58, I believe, of the Courts Act of 1993, Act 459, it provides, and I'm trying to paraphrase here, that in any proceedings and at any stage of the proceedings, a court, either on its own motion or upon an application by a party to the suit, may summon a witness to attend to give evidence or to produce a document in the possession of that particular person, or even excerpts from that document. But this is subject to the applicable enactment or irrelevant rule of law. And so what this generally means is that it is generally possible for a court to summon a witness or witnesses either on its own, so the court will exercise its power suo motu, or upon an application that is made by a party. But we need to note, most importantly, that this is discretionary according to Section 858 of the Courts Act. It's discretion. That's why it says the court may either on its own motion or upon an application of a party. So it's not necessarily as of right. So such summoning of witnesses in relation to proceedings, if it's before the High Court, for instance, if it's a matter before the High Court, and assuming an application of this nature is made and is successful, what will be done is that it will be done pursuant to Order 38 Rules 10 to 13, I believe, of the High Court Civil Procedure Rule CI 47 of 2014, where a request has to be made for the issuance of the writ of subpoena from the registry of the courts from which you seek that writ, or from which that writ is to be issued. And once this is properly done, a writ of subpoena ad testificandum ducis tecum will then be issued in the prescribed form. I believe it is Form 14, which can be found in CI 47, and it shall then be sealed, and it shall be served personally on the person to whom it is addressed within 12 weeks, I believe, from the date of issue of the writ. So it seems...
Now, let's briefly hold on here. We'll go back to the Supreme Court for the press conferences organized by the two political parties, the NDC and the NPP. So let's go back to the Supreme Court and hear out what the two parties are going to say. That's the NDC and the NPP. Their after court proceeding press conference. We'll be right back.
You do the change.
Are you ready? Are you ready? Okay. Good morning, ladies and gentlemen. Well, I don't see any ladies. Okay, so good morning, gentlemen. I believe you all followed the proceedings today, and of course, starting from Monday. On Monday, the petitioner closed his case after calling 3 witnesses. After closing his case, the respondents, per their counsel, informed the court that they had elected not to mount the witness box. What this means is that, or what that meant was that the chairperson, Jean Mensah, and the representative of the second respondent, Mr. McMenu, were not going to mount the witness box to testify and be cross-examined by counsel for the petitioner, Mr. Chikata. You will all recollect that they had filed witness statements in the case. So naturally, counsel for the petitioner opposed this request or application by the respondents on the grounds that not only had they filed a witness statement, but by 2 affidavits by which they opposed our request for them to answer interrogatories and for them to produce certain documents. The chairperson particularly had said that she'd be available for cross-examination. Now, the petitioner's point was that under the specific rule, Order 36, they had elected by this particular conduct to adduce evidence in court, and therefore it was no longer open to them to tell the court that they were not going to give evidence. Of course, on Monday you heard the superior compelling arguments by Mr. Chikata, and of course you heard the wishy-washy, insipid arguments by the respondents. Nevertheless, the courts have ruled in favor of the respondents, saying that they do not agree with us, that even though this is the EC, a constitutional body, the same principles that are applicable to ordinary people should be applicable to the Electoral Commission, and therefore they were upholding their request not to mount the witness box. Subsequently, also heard Mr. Chikata. He said, well, if that is the decision of the court, then he's going to apply. In fact, he's in the process of filing an application for us to reopen our case and to subpoena the chairperson of the Electoral Commission. And so that is the status now. So now, for us, those are important. There are important lessons to be learned from this. Now we have an EC who, when a request for information was served on them in the past, they refused to respond. We have an EC who was requested to answer interrogatories. They refused to respond. We have an EC that was served with an application or a notice to admit facts. They refused. We have an EC that was asked to produce documents relating to the election. They also refused that. That's the kind of EC we are dealing with. I mean, where are the principles of accountability? When is this EC going to be accountable? Any questions?
Yes, ma'am.
Counsel for Petitioner also announced that he will also file an application for review of the decision of the court. So that's 2 applications he'll be filing.
I'm sorry, review of the decision we had today.
Today's decision.
Okay.
He will apply for a review of that decision.
Okay, so maybe that even gives me the opportunity to ask this question. You have described as superior the argument made by Mr. Chikata against the application, and as wishy-washy the argument made by lawyers for the respondents.
Yes.
How would you, in that position, describe the ruling that we have from the court today?
The ruling is the decision of the Supreme Court of Ghana. We have nothing to do but to accept it. We disagree with the decision, and so we are going to file an application for review.
Madam, now that the court has set the 13th for all parties to submit their addresses, now that the court has set the 13th for all parties, 15th for all parties to...
Okay.
You file by 17th and your addresses, and the court comes back on the 18th. We know, as you said, you made an application or filing, you are going to file an application for a review, file another application for your case to be reopened. When you write your addresses and it's brought before the court, what becomes of these two applications, especially the one for you to reopen your case? Because then by the time your addresses would already be provided to the court. And what's next is that the court gives directions or a date for ruling.
Well, you heard his lordship. He said that nobody can stop us from filing an application. When an application is filed by a party, the court will deal with that application. And so we expect that the Supreme Court will take into consideration all these issues when dealing with the application.
Thank you very much, Madam. The Supreme Court was very clear in its ruling. It said that...
I can't hear you.
I'm saying the Supreme Court was very clear in its ruling. It said that a petitioner in an election petition case stands on its own strength, and not as the respondent's witness. Is that what you sought to do?
I didn't hear the last
I'm asking if that's what you sought to do. I mean, using the respondent witness to make your case.
Definitely not. We have the strength of our case, but as we have stated over and over again, the EC is accountable to us. She has to account for how did those errors arise. When did she discover those errors? What was the process of correcting the errors? We've seen for some regions there are different summary sheets, different collation sheets. How did that come about? Who's going to answer this? Apart from that, remember that the petitioner is not the returning officer. The petitioner does not declare results. It is the EC that, or the chairperson, that declares results in presidential elections. Does that answer you?
Well, my question is a follow-up to my brother's question. In giving their responses as to why the first and second respondents will not let their witnesses come to the box, the reason they gave was that the petitioner had not made a case strong enough to warrant them presenting any witnesses.
That's not what the Supreme Court... I didn't hear the Supreme Court say that.
Well, I would like you to give me your understanding of what but that's how I understood it.
I never heard them. I never heard them say that.
That was what the lawyers, the lead counsels for the respondents, first and second respondents, one of the reasons they gave was that the petitioner had not made a case strong enough to warrant them presenting witnesses in the box. If that's not the case, I would like a response from you as to what you understood.
As simple. If we disagree.
Well, that's because then my question then would have been...
You heard counsel for the petitioner on Monday. And we disagree with that position. That the evidence that has been given points simply to the fact that that declaration of 9th December is null and void. none of the two candidates got more than 50% of the valid votes.
And
there's only one declaration, 9th December declaration.
So the petitioner...
There were purported corrections. Have you seen any gazette notification dated on any of the purported corrections, the dates of the purported corrections? There is only one, 9th December, and the CI 135 talks about a declaration of 9th December.
Okay, so then, Honorable, if the petitioner does not get the chairperson of the EC to respond, does that then make your case a dead case? Because you seem to be insisting that she must, by all means, respond to certain questions.
And we will insist. We'll cross that bridge. But I believe that the petitioner we are convinced the petitioner has made a case.
Well, so the question is, if you are a doc, why would you not just allow the court to rule on what matters?
Why don't we allow?
To enter into the doc to be cross-examined, the court to rule on your case so far, since the respondents are withdrawing from.
That there are questions that we put to her that only she can answer. Nobody else can answer. Irrespective of what case we have put before the court, there are questions in relation to this case that she alone must answer.
All right. You keep saying that you are depending, or you're not depending on the witnesses of the respondents.
We are not what?
And that you have your own special case. Can you tell us the exact case you are standing on to deal with this petition?
Have you seen the reliefs have you read the reliefs?
Yes, I am saying that you just said that you are not basing, or you are not even expecting the witnesses to make a case.
I answered the question that there are specific questions that she has to answer. It's as simple as that.
Let's do some 5 minutes. Yo, Enyanom, I say, and ye bar court etc. No. As someone at the court nimpa or say ubua any say. A year my major mensa or dinner home electoral commission. I was say oba adakanum noba abeyi na no ana. Monim say na no juada. Yema a lawyer for ina kwa mobia kanasem. Na mu ina smutie in samoa. A year lawyer chachuchikata odina homa a year petitioner no or the two dwa ewo court. A wie chire no ye kani ina bomu na ye bae no ne ya court e ka kire ne se oni yen enya adwen se mame no ebeba abetena adakanum. Na ade a nwanwa ne se insem misedi wo ho a ye dia tudwa edi kan ye bisa ye no ono a asem odi betu court enum a wodi nsi atachire ose ye back cross examination obeyi no ye samba ye inspection ye ko nkrata bim ose ye back cross examination obeyi no na se ye du se brabetna de kanu mbisa wa o se mema menko adakanum nanso court enyabua se onu de onu wom ya adwe se maame no monko adakanum enti ama ye lawyer pani enso de ato court nanim se ne omo kae no woni wom nya adwen enti ye besan edin krata ba wom nim asra se wom nsan hwa asem no biom ye no nso fi wa ye san abesre court no se esense ni ye close ye case ana ye wie case ansana maame no ka se on ma adakanum nti ye san bebie ye case no so na ya sapina no ye ka se sapina ya makota hye se omra adakanum na nsem wo so yi na ese so no kwa ne returning officer o Ghana nsem so ebisa no obi ntimi yi no kire ono je mensa no betime yi no enti e ba makota ahye no edi sapina apoa atoa no akwa hye no so omra adakanum no omra mbe nsem na no enti we ni nsem mienu a ye lawyer for ye di omu maame no beba adakam adaka ne de ye gusu gina bebi egina se maame no so twa no okupa no awo se maame no oba be gina adaka num